When Arizona makes custody decisions for extremely young children, children are weeks or months old, we're really not going to differentiate it much from an older child. Gone are those days where a child had to be with mom for the first several months of their lives because they needed to breastfeed or whatever. Obviously, we have a lot more abilities now to bottle feed, formula feed, etc. And so the courts will typically treat very young children no differently than older children. Now, they may have less or more frequency in the amount of exchanges that you're going to have. We don't typically want a 1-month-old child to be away from either parent for something like 7 days, absent extraordinary circumstances. So typically you're going to see more frequent exchanges, but it is still possible to get equal parenting time. That is still totally within the realm of possibility for a very young child. Parents living in different cities or states can make custody very complicated. When you have a long distance situation with a child, especially that's of school age, and it's no longer possible to have month on, month off, or 2-month on, 2-month off type of schedule, we typically have to look at one of the parents as a long distance parent. And what that means is that parent is going to have typically a large portion of school breaks, and the other parent is going to be what we call sort of the school time parent. These are tricky situations. They're difficult to navigate through. Relocation of a child is always one of the highest burdens in all family law. These are tough cases. You want to have an experienced attorney helping you out with these types of cases. When Arizona law evaluates whether or not to relocate a child, we're going to look to ARS 25-408. Under that statute, the court actually lists out several relocation factors that the court can consider when trying to determine where the child should live and what's in the best interest of the child. Of course, in that determination, the court is required to make a separate finding relating to the best interest of the child as well. So we want that relocation to be good for the parents. We also want it to be good for the child. We need to make sure that it's appropriate because the court typically doesn't view moving a child away from another parent lightly. So they want it to be a really extreme circumstance in order to allow a relocation of a child. Interfering with parenting time in Arizona can be a very difficult situation, and there can be some extreme consequences for doing so. If you're withholding parenting time contrary to a court order, or you're just not allowing the other parent to fully exercise their time, the court can look really negatively on you. One of the best interest factors that the court has to consider is your willingness to give the other parent frequent, meaningful, and continuous parenting time with that child. And so if you're not doing that, if you're frequently withholding time, if you're not allowing the child to go to the other parent's house because the child is sick or other reasons, those are not going to warrant, and the court is typically going to look poorly upon you for doing so. Grandparents and third parties can have custody rights in Arizona. That's a process that we call third party or grandparent rights. It's governed by ARS 25-409. Under that statute, the court will actually consider things like the parent's wishes, which have to be given special weight. And then they'll, of course, consider this third party or the grandparent's relationship with the child, as well as why the grandparent or the third party isn't having the time that they feel they should have. Grandparent rights are a difficult burden. They're a high burden. It's really important that you have an experienced attorney walking you through that process if you're trying to obtain or defend against someone seeking grandparent or third-party rights.